Hi everybody, I'm back with part 3 of the Idaho 4 Moscow murders April 9th hearing for motion in limine, which is just excluding evidence from trial, or they're trying to, and we are on motions 5 and 6, and 1 through 4 is below, so make sure you go watch those first before watching this video. Motion 5 is about the DNA statistical / evidence, and motion 6 will be about the touch DNA. Now they start motion 5 talking about motion in limine number 14, statistic sheath evidence will be presented because it was presented at the grand jury. They start talking about the DNA under the victim's fingernails, assuming this is Maddie, and that it was inconclusive. This is where Becca Barlow tried to come up, and she was talking about the different numbers, and the statistics wasn't making too much sense, so I think once we hear from the actual professional, it will make a lot more sense. She was just kind of reading off, but she said that cybergenetics versus the state labs, it was 2.5 times less likely that it was Brian's DNA and 2.8 billion less probable. She was talking about the software that was used to create the statistic, and the defense expert re-examined it, ran it through new software, and it had strong exclusionary statistic for Brian. It had anywhere between 5,000 to 100,000 probability, less probability that Brian Kohberger is present. All the numbers point to exclusion and are highly prejudicial to Brian Kohberger. The defense said that they want to prevent the state from including an exclusionary statement. So this is where the state got back up and started talking about a buffer zone. Now there was buffer zones in other cases in Idaho. The Karen Reed case had one, and they looked at it as more of a greater than 1, it means inclusion, and less than 1, it means exclusion. And they had a range from 0.01 to 100, and it was inconclusive. So then the judge starts commenting, saying that judge suggests his understanding is that the perp was clothed in such a way that the DNA didn't get under Maddie's fingernails. That's how they're going to argue this. But what I don't understand is either how do you get DNA in a knife sheath but not under Maddie's fingernails? And I'm assuming you'd have to put the DNA on it before you went to the scene, if I'm understanding that correctly. That's the only way that I can see this actually happening. They did state that there were no defensive wounds on Maddie Mogen, and that was the first time we were hearing this detail. The defense agreed that if the state wants to include an exclusionary statement, that they have to come to court and state as such and before the judge before they bring it to trial in front of the jury. Now we're on to motion 6, which is regarding the touch DNA. So there was 2 parts to this that they mentioned, and it's excluding the word touch and the opinion of Riley Nowlin. Number 1, the touch, the term touch. DNA evolution of testing can pick up from items with no stains, bloods, semen, etc., allows a conclusion through description. 3 experts by defense, misleading by touch, verbiage being used. So they're saying that if they use the word touch, it's misleading because there's other ways to describe it, and that they're concerned with using the word touch because then it makes it seem like Brian would have had to have physically touched it to get that DNA on the knife sheath. But as we know, touch DNA can come from anywhere. Like, you can go and touch a pillow at a store, and then that person takes the pillow home, and now your DNA is on the pillow at their home if they got murdered, right? So that doesn't mean you physically had to touch it. It could mean you touch something else, someone touches that said item, then touches that item, now your DNA is on that item, but you never touched that item. Does that make sense? It's like you touching an item, or you shaking someone's hand, and that person immediately goes to a store and touches another item, and then now your DNA is on that item, but you never touched it. So that's what they're trying to prevent at trial from being misunderstood by the jury with the word touch. And their defense experts all agree to this. Now, with regards to Riley Nowlin, it says, does not describe touch in opinion, rejects term trace. You don't need to use to show how DNA moves in an environment. Becca Barlow, who's arguing about this for the defense, states that studies cannot tell when DNA placed. Riley not qualified to give such an opinion. She went on to talk about how Riley has no expert training, how and when transferred DNA occurs, and she's highly speculative. DNA can be indirect transfer, quantity plus single source equals direct contact, and keeps changing her opinion throughout her written statement. No scientific support to her opinion. Now the state got back up and said science cannot conclusively possible secondary transfer, and then they said single source she believes is the primary source. The defense expert used touch DNA and report. Okay, so the defense expert actually used the word touch DNA in their report, so they're arguing why is it that the defense experts can use that verbiage but they can't. So that's where that really kind of hurt them, because it's like if their experts had never done that, then they had a little bit more of a leg to stand on. He said that, being Mr. Nye, said he doesn't understand why they would ask to limit use of touch DNA when their own expert used it. The judge doesn't like policing common verbiage because people slip, which could lead to a mistrial, and worried mistrial can happen if accidentally slips, if order is not to use those words. The defense got back up to redirect and said, like, language is important. Scientists held to high standards. She's confident Nowlin can avoid these terms. It's a personal opinion, not scientific fact, what her statement is, and we can't speculate. She didn't talk about support for single source. And this judge said he will consider the Riley Nowlin motion and not going to restrict touch language, encourages parties not to use the term. So I actually have enough time to get through motion 7, which is regarding the suspect vehicle number 1 language. So they're saying that it's highly circumstantial case, video of 1112 at King Road, several views of the vehicle, state will use other videos, do not have one continuous video, stitching together the vehicles and calling it suspect vehicle number 1. They're saying that the FBI Emil only identified the vehicle from one single video and not all of the videos stitched together. And he originally said 2011, 2013, when Brian's car is a 2015. And then later, but in his email, he supposedly said, you might want to stretch it to 2016. But he might have been correct on his assumption. We always thought, well, maybe, how does an FBI get things wrong when he's an expert and does this every single day? But maybe because he was only shown that one clip, and that clip might have been a 2011 to 2013 Hyundai Elantra, and not what they're stitching together with all these videos to make it seem like it's Brian's 2015. So he might have been right all along. So the defense just doesn't want them using suspect vehicle number 1 to make the jury assume that this is the same vehicle and insinuate it is, when they don't know for sure. The state was saying that they have the ability, they being the defense, has the ability to cross-examine, and then the defense got back up and said, well, you can show and talk about it, but not say it's the same vehicle. The judge started talking and saying that it originally was 2011, 2013, and then he had said they were saying it was the 2014 and 2016 after December 19th. But judge corrected them and said that the email that Emil, Special Agent Emil, sent to the state and essentially the defense about his opinion was before Brian Kohberger was identified. So when he sent it to the state and they later gave it to the defense, it did state 2016 in it. And this is before they identified Brian. And he strongly talked about that the state should not be making conclusions outside of closing, either party. So they cannot argue things outside of their opening and closing statements. He's going to be very strict about that. So that is actually motions 5, 6, and 7, and we will continue in the next video, but those are from the April 9th hearing for motion in limine for Brian Kohberger, Idaho 4 Moscow murders. If you'd like to hear more, make sure you hit that follow button, and I will be back.